Hello, everyone. My name is Ariella Wagner. I'm the founder of SunRay Construction Solutions, a national construction document service. We help thousands of general contractors, subcontractors, and suppliers secure their lien and bond claim rights. Today, we have a great webinar in the state of Arizona conducted by attorney Kevin Estevez. And the topic today is what happens after I record my lien? How do I get paid? Which is such an important issue for customers out there after they lien a property. So without further ado, I'd like to introduce Kevin.
Thank you, Ariella. My name is Kevin Estevez, and I'm an attorney at the law firm of Holden Willits in Phoenix, Arizona. And I'm going to talk to you today a little bit about what happens after I record my lien and how do I get paid. Hopefully I can give some technical and practical advice on this subject. So the last webinar we had in this series was titled Arizona Preliminary 20-Day Notices, Lien and Bond Claim Refresher with Pro Tips. And if you attended that webinar, you know we covered a lot, but mostly what we covered had to deal with how to preserve mechanics lien rights and bond rights in Arizona. And so before jumping into today's topic, I'd like to take a step back and recap some of the important points that we covered last time because they will be relevant today. The first and foremost in preserving mechanics lien rights in Arizona is to timely serve a proper preliminary 20-day notice. In Arizona, except for laborers for wages, every mechanics lien claimant must serve a preliminary 20-day notice. If you fail to serve a 20-day notice at all, you will forfeit all your lien rights. If you fail to serve a timely 20-day notice, you will forfeit a portion of your lien rights. And how much of your lien rights are forfeited depends how late in the day you serve your preliminary 20-day notice. Remember, 20-day notices, they catch back 20 days. So the best course of action, best standard practice is to serve a preliminary 20-day notice right when you begin work on a project or you deliver materials to a project. And that way, it will catch back to the beginning and you will be covered for the entire project. If you serve the 20-day notice late, like I said, it reaches back 20 days. And so say, for instance, you start work on a project on July 1st, but you don't issue a 20-day notice until July 30th. Well, it would catch back 20 days and would give you lien rights for the work done from July 10th going forward on the project. And again, that's provided that the amount in the 20-day notice is correct and everything else about the 20-day notice is correct. But that period of time from July 1st to July 10th, you would not have lien rights for the labor and materials furnished within that window. And of course, you know, extend this up further as a project goes along. You know, that time frame can get bigger, and the time with which you're not afforded lien rights can grow if you wait to serve a 20-day notice. So in short, get your 20-day notices served at the outset of a project, and that is step one in preserving mechanics lien rights. Second topic here is, we didn't cover this last time, and I believe it is on the docket to cover at one of our upcoming webinars, and it relates to lien waivers. Second topic, don't forfeit lien rights by signing an improper or incorrect lien waiver. Arizona has statutory lien waiver forms that those in the construction industry are required to follow. So you want to make sure that the lien waiver forms that you sign comply with the statute. In addition to that, you want to make sure that the lien waiver forms that you sign are the right type. Arizona statutes provide for 4 types of lien waivers. You have conditional progress waivers, unconditional progress waivers, conditional final waivers, and unconditional final waivers. And so you want to make sure that you are signing the right type of lien waiver for the given situation. Finally, when you're filling out your lien waiver, you want to make sure that you are inserting the right date, so the period within which you may be giving up lien rights is correct, and you're not extending that period beyond what it's supposed to be and short-circuiting your lien claim by signing a waiver with an incorrect date. Third step, third general rule, third step in preserving lien rights is to timely record a statutorily compliant notice and claim of lien. And that needs to be recorded in the county recorder, with the county recorder in the county where the project is located. And we talked about this last time, but notices and claims of lien need to be recorded within 120 days of quote unquote completion of the project. And when I say completion of the project, I mean completion of the entire project. So if you are a labor or material man who furnishes labor materials at the outset of a project, you may have a much longer time to record your lien than the folks who are doing work at the end of the project. But completion for purposes of Arizona statutory lien scheme is defined as, so let me take a step back. You need to record your lien within 120 days of completion or within 60 days of a recorded notice of completion. So we talked about that last time. Recorded notices of completion can be sent out by an owner or someone upstream on a construction project, and they can short circuit the time within which you have to foreclose on a lien. If a notice of completion is not recorded, you'll have 120 days from completion to record your lien. Completion, although you have 120 days, that term can vary depending on the situation. If a certificate of occupancy is issued on the project, you will have the completion is defined as 30 days after the C of O is issued. If no C of O is issued on a project, completion is the last date materials are furnished. So you'd have 120 days in that instance from the last date that labor or materials were furnished to record your lien. If work is stopped short of completion, for it can be a number of reasons, but if it's stopped, then you have 60 days after the cessation of labor. That 60 days after the cessation of labor is defined as the completion date, and then you have 120 days after that to record your lien. So those are the steps that you need to take just from a 30,000 foot general level to preserve your lien rights in Arizona. So say that you do all those steps, you comply with the steps, you get your 20-day notice served, you don't forfeit lien rights inadvertently through signing an incorrect or improper waiver, and 3, you timely record your notice and claim of lien. What happens next? Well, after that, you still have several hoops you have to jump through. First, and we talked a little bit about this last time, you must timely serve the notice and claim of lien, and we'll talk about what that means. Second, you need to be on the lookout for lien discharge bonds. These can change. These are statutorily available to owners and others on projects if they want to remove a lien from certain property. And they, as a lien claimant, they change the actions you have to take to collect the money that you're owed. Third, you must sue to foreclose the lien within 6 months of recording. And we'll talk about that in more detail, but I just talked about the deadlines for filing your notice and claim of lien, and I used days to calculate those deadlines. 120 days after completion, and then you can add 30 days if a C of O issued. You can add 60 days if the work stops on the project. But one thing to bear in mind here is that the deadline to foreclose the lien is not measured in days, it's measured in months, and sometimes that can be a material difference. And then after you sue to foreclose on your lien, then you must record a Lis Pendens within 5 days of filing suits. So those are the steps that once our lien's recorded, you're not out of the woods yet. You have to comply with these steps in order to preserve your lien rights. And we'll talk about each of those in more detail going forward. So first, we'll talk a little bit about serving a notice and claim of lien in Arizona. Once a lien claimant records their notice and claim of lien in the county recorder where the project is located, they are obligated to serve a copy of their notice and claim of lien on the property owners within a reasonable time of recording. The statute does not define what serve means, but thankfully we have an Arizona case that addresses that issue. And that case is Old Adobe Office Properties versus Gin. And what that case says is the term serve for purposes of Arizona's lien statute requires that service be made by mail, first-class mail, registered or certified mail, with the sender obtaining a certificate of mailing, receipt of registration, or receipt of certification. What this is analogous to is the service of a preliminary 20-day notice under Arizona's lien statutes. So if you serve your lien that way, you have complied with the statute and it's deemed a good service. You can also, however, serve your lien the same way process is served in Arizona, by serving the correct person that's provided for in either the corporate structure or the statutory agent of the owner of the property. And if you serve them personally through a process server, that is also good service. I mentioned a second ago that, and the statute provides that the lien must be served within a reasonable time of recording. Like service, the statute does not define what is a reasonable time after recording. In short, the notice and claim of lien should be served promptly, because the Arizona Court of Appeals has held that absent unusual circumstances, the notice requirement of 33-993A, which is the statute that provides for service, will not be met merely by appending a copy of the notice and claim of lien to the complaint filed in the action to foreclose. So as a general practice, the lawsuit that will be filed, and we'll talk about that in a second, to foreclose on the lien, you will attach a copy of the lien to the lawsuit, and that lawsuit will be then served on the owner and the other necessary parties to the lawsuit. But Arizona Court of Appeals has said that absent unusual circumstances, that is not going to be good enough in terms of complying with the service requirements in the statute. So long story short, simple answer is to get your lien served promptly after recording, and don't wait on that. And so the topic of this seminar, as we mentioned, is what happens after I record my lien. And so we've covered really the first step in what happens after a lien is recorded. The second part is, how do I get paid? Well, throughout the process, and we'll go through the entire litigation process, so you all have a good understanding of how that works. But there are various points in the process that allow for the parties to get together and negotiate and hopefully resolve their differences and allow for the contractor or supplier to get paid. And the service of a notice and claim of lien often is one of those times that will naturally facilitate negotiation. Typically, if you have not had luck speaking with the owner or the folks upstream about getting paid, once they get served with a notice and claim of lien, they tend to take you a little bit more seriously, given the impending nature of a lawsuit. And so hopefully that opens the door to communications between the parties and allow resolution of the lien claim without having to go further in the legal process. Second thing I mentioned that we're going to talk about today is to be mindful of lien discharge bonds. After a notice and claim of lien is recorded, a property owner has the option of posting a statutory lien discharge bond pursuant to ARS 33-1004. And these discharge bonds must be recorded in the county where the project is located and served on the lien holders. And what these do is they effectively discharge the property from the lien. And if for lien claimants, they shift the focus of your target in pursuing the funds that you're owed. Instead of filing a foreclosure lawsuit to foreclose on the property and have the property sold at the end through judicial sale and the proceeds split among the various lien claimants, your focus is now on the bond that has been posted and recorded to discharge the lien. So if a lien discharge bond is posted by an owner or a general contractor or someone upstream, and a lawsuit's already pending, the lien claimant must amend his or her lawsuit to add a claim on the bond, and by statute you have 90 days to do that. If a lawsuit is not pending, the lien claimant must file suit against the bond within 6 months of recording its notice and claim of lien. So it's worth noting here that although the focus of your claims and your lawsuit change with the recording of a lien discharge bond, the time frame within which you have to pursue that lawsuit doesn't change. If the owner or general contractor posts a lien discharge bond, then as a lien claimant, you still have 6 months from the time that you recorded your notice of claim and lien to file suit against the bond in this case. All right, so jumping into the mechanics of a lien foreclosure lawsuit in Arizona. A foreclosure lawsuit asks the court to order the sale of the property to satisfy the liens. Mechanics lien claimants are required in the lawsuit to prove the validity of their lien and the value of the materials or services provided. As mentioned earlier, the lawsuit must be filed within 6 months. If no foreclosure lawsuit is filed within 6 months of when the notice and claim of lien is recorded, the mechanics lien will expire by operation of law. Necessary parties. This is something where sometimes folks get tripped up. You need to sue to foreclose against all others holding an equal or inferior interest in the property than you do as a lien claimant. So what does that mean? This means that other lien claimants, other folks that have recorded liens on the property on this project, are of equal priority to you. All the mechanics liens on a project resulting from let me take a step back. All the mechanics liens resulting from certain work on a project have the same priority, regardless of when the work was performed. They go back to the first day that work was performed on the project, and that's where the priority for the mechanics liens is set. So any claimant on the project is going to be of an equal interest to you, and so it's incumbent upon you when you sue to foreclose on your lien to name all of the other lien claimants. And the easiest way to make sure that this is done properly, of course, you can search the county recorder website and look for other lien claimants on the project. And typically we have a situation where either you as a material supplier or a contractor is not being paid. Typically it means that other folks aren't being paid as well. So you can go to the county recorder's website and look there and see if there are any other lien claimants. But the most efficient way to do it, and the way that provides usually the most security as a lien claimant, is to obtain a litigation guarantee from a title company. And that is a report from the title company. It's essentially a title report on the property where they identify additional potential lien claimants. So that's often a very good step at this stage in the process before you file your lien foreclosure lawsuit, to make sure that you're getting all the necessary parties. I say here on the slide that it's important to be careful with lenders. Often, but not always, lenders have a superior interest to lien claimants. And that's because usually, in most instances, lenders are savvy enough where they know to have their lien and interest in the property recorded before any construction work begins. And so long as they do that, they will have a superior interest to lien claimants. But that's not always the case. If a lender records their interest after construction work begins, usually that means there is a broken priority, and there's some super technical legal arguments that in those circumstances could mean that even if that happens, there's not broken priority, but usually that means there's broken priority, and all the lien claimants would then have a superior interest to the lender on the property. But this is a very complex situation that really needs to be analyzed in each circumstance. But just know that that's something that has to be examined carefully in the circumstance when you are about to file your lien foreclosure lawsuit. If a lien foreclosure lawsuit is pursued all the way to the end, and like I said earlier, there are ample opportunities for settlement. But if it's pursued all the way to the end and the lien claimant prevails, then what happens is the property is sold and the proceeds are split pro rata between the different lien claimants. In circumstances where properties are upside down, like happened in the 2007, 2008, 2009 window, lien claims may not be a fruitful method of recovering sums owed. Thankfully, we're no longer in that real estate environment, and properties are increasing in value. And so in those circumstances, lien claims can be very valuable. I noted here that courts may award the successful party its reasonable attorney's fees in lien foreclosure lawsuits, which can be important. And the topic of attorney's fees in Arizona is an interesting one. Just generally speaking, we have a statute that's similar to the statute I'm referencing here that relates to lien foreclosure lawsuits, but it generally relates to contract disputes in general. And the statute says that the prevailing party may be awarded their reasonable attorney's fees in breach of contract lawsuits. So if you file a lien foreclosure lawsuit, you don't have a contract directly with the owner, you're probably going to have a contract claim against the folks upstream on the construction project who haven't paid you, as well as the lien foreclosure lawsuit. And you are also, if you have a contract directly with the owner, then you're probably going to have a breach of contract claim against them, as well as your lien foreclosure claim. And so you'll have a basis for fees under the lien statute, and you'll have a basis for fees under the just general litigation statute, and you may have a basis for attorney's fees under the contracts between the parties. But the thing to note in both the statutory provision for fees in a lien foreclosure lawsuit and the statutory provision for fees in general contract litigation is the word may here in the slide. And it gives the court discretion whether or not to award fees. Typically in Arizona, courts do, but that's not always the case. So be mindful of that. So say you record your lien, you then serve your lien timely and properly to preserve your lien rights, and then you sue to foreclose within 6 months. You are still not out of the woods. There's still an additional step you have to take pursuant to the statutes to preserve your lien rights, and that is to record a Lis Pendens. And that Lis Pendens is it's a notice of pendency of action that is designed to provide general notice to everyone that a lawsuit is pending that affects title to the subject property. And pursuant to ARS 33-998, the Lis Pendens needs to be recorded in the county where the project is located within 5 days of filing suit. And so that's a fairly quick deadline that you need to be on top of when you file a lawsuit to foreclose on your lien. So once that Lis Pendens is filed, that's really the last step in preserving lien rights, and provided everything's done properly, all the way from issuing a 20-day notice to filing suit and recording your Lis Pendens, then you are in the court system, and your action can and should progress. The Lis Pendens, pursuant to the statute I cite here, ARS 12-1191A, shall contain the names of the parties to the lawsuit, the object of the action, the relief demanded, and a description of the affected property. So that's an overview of the litigation process and overview of the steps you have to take to preserve a mechanic's lien claim in Arizona all the way till you get to the point of litigation. And as you can see, it's very technical. And there's plenty of Arizona cases that hold that Arizona lien laws are to be liberally construed in favor of the lien claimants. However, that said, the courts still strictly adhere to the time frames that are prescribed by statute. So these time frames are something that you have to be mindful of, and make sure you're monitoring as projects progress and as payment disputes arise. If you make it all the way through, you record a lien, you get to a lawsuit, and you resolve that lawsuit through settlement, or you get a judgment and you collect that way, it's incumbent upon you as a lien claimant then to record a release of lien. And this is a document that you record that says that the lien's been satisfied, and you want to make sure that you record that only when you receive payment in full and not before. And once you receive payment in full, you have 20 days to issue that release of lien and have it recorded. And that lets everyone know that the lien is no longer in effect. Failure to provide such a release subjects lien claimants or persons, and that refers to those who may be named or signed the notice and claim of lien, to liability in the amount of $1,000, and also liability for actual damages of the owner at that point. So that's something that you want to be mindful of if you do get paid, and hopefully you will, that you promptly record a release of lien. Generally, like I said, if there is, it's been a while since I looked at the stats, but I think it's something like 99% of all civil cases in Arizona are resolved short of trial. So chances are, if you do file a lien foreclosure lawsuit, like I said, that it will be resolved short of going all the way through the litigation process through settlement. And if the service of the notice and claim of lien right after it's recorded doesn't prompt and get the folks upstream to take your payment claim seriously, then chances are the filing of lawsuit will, or as the lawsuit progresses and things become more expensive, hopefully at some point during that time, it will settlement discussions will be facilitated. And chances are, given the stats in Arizona, that's how you will get paid through settlement and resolve your claims that way. So that's, Ariella, that's really all I had to talk about today. I'm happy to answer any questions if there are any.
Absolutely. If you have any questions on the right side of your GoToMeeting box, you can ask them right there. While we're waiting, if anyone does have any questions, I think quite something that people say, when do you really want to get the attorney involved? At what threshold do you make a business decision where it seems financially, it seems like it's the right decision to make? And two, are there alternatives? So for example, let's take it, if it's under the small claims court, let's take it to small claims court if it's under a certain dollar value. What's that dollar value, that threshold in Arizona for small claims?
So small claims is, I believe, between 2,500 and 5, or less than 2,500, I believe, or less than 5,000. I'm sorry. And then there's justice court, which is anywhere from, I think, 2,500 all the way up to 10,000. I believe those are the limits, Ariella. And then anything above 10,000 is within the purview of Arizona Superior Courts. However, given lien foreclosure, given the complexity and the relief afforded in lien foreclosure lawsuits, the jurisdiction for those is in Superior Court.
Okay, great. So people have, if it's under a certain dollar value, they definitely have options that are there for them. And then obviously, first thing would be to definitely speak with you as the attorney and maybe send a demand letter. And then if the demand letter doesn't work, of course, proceed forward with a foreclosure if necessary.
Yeah, I think that's typically, hopefully, like I said, there is numerous opportunities along this path for resolving disputes, and hopefully a demand letter early on will facilitate discussions and get the payment dispute resolved. Um, if it doesn't, to get back to your, I think, initial question, I think the time you want to involve an attorney in the process is when you get to the point where you're going to have to uh, record your lien, because at that point you want to make sure that someone is going through the documents, looking at your lien waivers, looking at the amount of your claim, and making sure that um, that that the amounts are correct, um, the forms are filled out correctly and when they're recorded, because there are in Arizona severe penalties for wrongfully recording liens on property. So
Right.
you don't want to do that.
In the very beginning, I know that we went over one of the slides, and this would be, question I think most people should have the answer to. So in the state of Arizona, before you even start working on a project, I know the laws are such that it's to the prevailing party, but do you also think that maybe an arbitration clause, things to make it a little bit easier for people if it gets ugly? Because of course, everyone knows in the beginning everything's great, but are there any recommendations that you have as an attorney on what subcontractors and suppliers can do early on to protect themselves? So if it gets to the situation where they do have to foreclose, what they can do.
Yeah, arbitration can be a very useful tool to mitigate the cost and expense associated with litigation. And I said, you're correct, I said prevailing party in the lawsuit, and I talked about the statutory basis for those uh, potential fee awards to the prevailing party. One thing that to be mindful of is if you have a provision in your agreement, in your contract, with whomever on the project, and that provision says that instead of saying may be awarded attorney's fees, it says the successful party shall be awarded their fees. That removes, pursuant to Arizona law, the discretion of the court to award the prevailing party their fees. The court can still evaluate fees for reasonableness, but at that point, the court has to award fees, and it's not in the discretion whether or not to award fees at all. So, as a party that wants to better be able to predict um, the effect of litigation, it's helpful to know whether or not the prevailing party is going to be awarded their fees, and that will help you get a better gauge on what the process may involve, and what the results may be. It'll give you a little bit more clarity on that. Now, with respect to arbitration, many construction contracts have arbitration provisions. Like I said, they can be efficient ways to cut down the costs. Um, there are times, however, when they can be more expensive. One of the drawbacks of arbitration is sometimes you'll have parties that have arbitration provisions that call for a 3-person arbitration panel. And so in those circumstances, then you have to pay, in addition to the attorneys litigating for you, you have to pay for 3 arbitrators, as opposed to a judge that you don't have to pay for. So those types of provisions can be very expensive, and they can be a reason where arbitration will sometimes exceed the costs that you would incur if you had gone into litigation. It's really a trade-off. If you go down the arbitration route, typically discovery and the litigation process is shorter, which is less expensive, but the additional arbitrator fees have to be paid, and those can wind up being could be quite expensive. Now, I will say that on lien claims, those are outside the purview of arbitration, um, given the order that you would get at the end of a foreclosure lawsuit to sell the property. That's in the proper purview of a superior court judge here in Maricopa County. So if parties do litigate do arbitrate disputes, and there is a lien claim that's involved in disputes between the parties, typically what happens is they'll either litigate that in superior court and put arbitration to the side, or they'll arbitrate and they will stay or toll the lien foreclosure action while the arbitration's going on, and have that claim potentially there if needed at the end of the arbitration.
Well, definitely mouthful, and thank you.
Sorry. Yeah.
I'm sure people can't on the webinar speak, but I'm wondering what faces are looking like. But Kevin, thank you so very much for such an educational webinar. You did a really fabulous job. And to any of our attendees, if you think about a question, or you were nervous to ask a question, or there's something really pressing, you're like, yeah, I want to attend this webinar, but I kind of want to know something else. Please, we're here to educate you. So please send us an email, and we will absolutely answer any questions you may have. So again, Kevin, thank you so much. And to everyone, I wish you a sunny day.
Thank you, Ariella.
Thank you.